Well, I think we'll go ahead and get started. Thank you so much, everyone, for coming out for today's event. This is an installment of the Dykehouse Program Workshop in Money, Banking, and Financial Regulation as part of the Ness School of Management and Economics. And I want to extend a big thanks to the Ag Heritage Museum and Gwen for collaborating with us on this event. We thought that this setting would be really fitting for the article that Hannah is going to be presenting today. She's going to be discussing her recently published law review article titled Including Unmarried Women in the Homestead Act of 1862. So before I turn it over to Hannah, I've just got some background information about her I'd like to share with you. Hannah Haksgaard is a professor of law at the University of South Dakota Knudsen School of Law, where she teaches in the areas of property law and family law. She writes on those topics as well as the rural lawyer attorney shortage. She received her BA from the University of Kentucky and her JD from Berkeley Law. After law school, she clerked for federal judges at the District of South Dakota and the 8th Circuit Court of Appeals. So let's give a big round of applause for Hannah for being here with us today.
Thank you. Well, hello, and thank you all for coming today. I want to thank you both the Ness School of Management and Economics and the Agricultural Heritage Museum for having me here today, with a special thank you to Brittany McKnight, who invited me and organized me coming to give this talk. So the paper I'm talking about today is called Including Unmarried Women in the Homestead Act of 1862. It is available in an open access journal. I also have a few paper copies up here. If anybody cares enough to read sort of the dense version of this afterwards, you can snag one. It was published in the Wayne Law Review earlier this year. And before I begin any of this, let me say I'm a law professor, not a historian. So my level of expertise is mostly on the legal aspects of this piece, but the paper, of course, is both about law and it's about legal history and it's about the lived experience of female homesteaders. It also deals with land ownership by women. And as we all know, land ownership is a huge factor in economic status of women and really the economics of anyone. So the paper itself is part of a much larger project about female homesteaders on the American frontier. About a decade ago, I read a book about female homesteaders in Montana. The author in the introduction laid out the law, and she noted that in the United States, the Homestead Act allowed women to claim homesteads. She observed that Canada had done things differently. So in Canada, only men were able to claim homesteads, but in the United States, women could as well. She observes that this has a huge impact on the settlement, right, in the United States versus in Canada. And she went on to write a really wonderful book that drew out the historical narratives of female homesteaders in Montana. But of course, she's not a lawyer, so a lot of the legal details of how we got to that don't appear in that book. But the book piqued my interest and made me wonder, what are all the legal elements that go into the fact that we end up with female homesteaders? So several years ago, when I started researching the law portion of this, I naively thought that I would be able to write an article that told the legal story of how women ended up with the right to homestead and how the law impacted female homesteaders. I thought I could quickly sit down, write an article that told this story. Not only about the law itself, but also how women took advantage of this law or not over time. However, I quickly realized that there was way too much information to put into just one article, and so instead I decided to break it up into various pieces, tackling small pieces of this legal question in subsequent papers. What I'll be talking about here today is the second paper in this series of a long project that I suspect will be at least a half dozen articles as I continue to confront these legal issues. So this paper then is meant to be one small part of telling the story of how female homesteaders took advantage of the laws in the United States that allowed them to claim land. Specifically, this paper is about why Congress decided to include unmarried women in the first place. So in that sense, this paper is about the legislative history in the 1800s. It's about gender roles in marital relationships in the 1800s. And it's about property ownership by women in the 1800s. So that sets me up for the paper. But before I get into the paper itself, let me start with this caveat. We all know that American public land distribution was built on Native American land dispossession. The men and women who homesteaded under the Homestead Act engaged in settler colonialism, and they did so at the behest of the federal government. The United States federal government felt they used free land to incentivize settlers to move to frontier areas, in part to force Native Americans off of their homelands. The federal government felt like with more settlers, less military force would be needed, and in fact, the federal government was right about this. So this paper, though, is not about federal policy towards Native Americans. It obviously matters, though, to the context of thinking about the passage of these laws and how women lived under these laws. I will not be talking separately about Native American women today because they were not qualified to homestead under the laws, so there are no Native American women who would be impacted by what I'm talking about today. So the paper itself, and the way I did the analysis, proceeds in 3 parts, which I will take in order. So in part 1, I start with background information for what happened before the Homestead Act of 1862, and there's really 2 relevant pieces of background information to understand. So first is the history of how the United States federal government gave out land. There's a very long history of the colonial governments and then later the federal government giving out free land to settlers in order to entice settlement in certain locations. This was occurring as early as the 1600s in the eastern colonies. Once the United States formed following the Revolutionary War, the federal government began giving out land. It did not take them long to do this. Only 2 months after the Declaration of Independence, the Continental Congress passed legislation promising free land to soldiers. Initially, though, Congress largely thought of the federal land holdings as a way to generate income. As the federal government began to acquire more land on its march to manifest destiny, it tried to sell that land off. And while it was able to sell some land, it turns out that selling land was not particularly successful at getting the land into the hands of small farmers. It became clear that a different strategy was needed, hence the idea of a Homestead Act that would give out free land to settlers. Even though before we get to the Homestead Act of 1862, there were smaller and more targeted laws that gave out free land. There was also the Preemption Act of 1841, which is a very broad act that allowed squatters to purchase land after they had already lived on it. Those early laws, including the Preemption Act of 1841, did not allow unmarried women to claim land. Some of those laws were limited specifically to men. Others were limited to heads of families. Some did specifically list widows as being included. But until the Homestead Act of 1862, unmarried women never got federal land grants directly. So in that way, the Homestead Act of 1862 was a major change for women's rights. It was, though, true that although the Homestead Act of 1862 was a big change, women's rights were never central to the debates about the various laws that Congress debated. Instead, Congress was more concerned about Native American policy, more concerned about immigration, and more concerned about slavery. Slavery was particularly relevant because there was general Southern opposition to Homestead Acts because the Southerners feared that new states formed after these population booms would be abolitionist and therefore voting against the slave interest of the South. So it is not at all surprising, understanding this history, that the Homestead Act was passed during the Civil War after the Southern states had seceded. So the second piece of relevant background information is how the government treated unmarried women. The short version is that in the mid-1800s, unmarried women did not have many rights. The assumption that policymakers made was that all women would ultimately marry. And if all women would ultimately marry, then all women would ultimately be represented by their husbands. Laws were written to encompass men and assumed that those men would have wives, but the law did not give special rights to unmarried women simply because they did not have husbands. Generally, courts and legislators simply ignored unmarried women, sort of neither specifically restricting their rights nor giving them additional rights beyond what a married woman might have, which was, quite frankly, very little. So understanding a little bit of the historical background of how the law operated, I turn to then in part 2 of the paper a very detailed statutory history of the Homestead Act of 1862. So the bulk of this paper is this dense statutory research. My methodology for this was reading congressional debates published in the Congressional Globe. I also consulted biographies of legislators and some statutory history books. There is a lot of information about the homestead laws in secondary sources, but not very much about the homestead laws and unmarried women. In the paper, I cite every instance where Congress talked about unmarried women as they talked about the Homestead Act. And I also track the language of each law that was proposed and subsequently rejected. So in essence, the homestead laws gave free land to settlers if settlers would occupy the land, cultivate the land, and reside on the land. So one debate in Congress was whether there should be an offering of free land at all. But another fight in Congress was if we are going to offer free land, who should qualify to get that land? We call the portion of the law that defines who can get the land as a qualification clause, as in, who is qualified to claim land under the Homestead Act. I started reading congressional records in 1843 and ended in 1862 when the law was passed. A huge number of different homestead bills were proposed over that 20-year period, and each time a bill was introduced, I read the original bill to track what language was used in the qualification clause, because this tells us who Congress was thinking about including. I also looked at the recorded debates on those bills. Basically, the way the congressional records work is whenever the bills were discussed on the floor of the House or of the Senate, there's a record of what was said. Those records appear in what we call the Congressional Globe, or if they're longer speeches, in the appendix to the Congressional Globe. I read all of these transcripts and looked for any mention of unmarried women. So just to give you an idea of what I found in this reading, let me give you a little bit of timeline of the types of bills that are proposed and the types of debates that happen. In the 1840s, when I started reading, there was not much discussion of unmarried women, but a variety of qualification clauses were proposed in the House. These include several bills proposing homesteads for heads of families, and a head of family here would be defined as any married man or any adult with children. One proposal simply listed any person, which presumably would have included women. Another proposal would have limited homesteads to only male citizens. One proposal had a qualification clause for any man, maid, or widow being the head of a family. Another only for every poor man who is the head of a family. Another for any citizen or any female who is the widow or daughter of any citizen. And yet another was for 40 acres to a single man, but 80 to a married man. Congress obviously is all over the place in the types of qualification clauses that are being proposed. Overall, the 1840s then saw a lot of homestead proposals, but very little movement forward on the issue. It seemed like Congress was too nervous to take the Homestead Act seriously because everyone realized that slave states would object to any broad homestead legislation. So in 1850, debate finally moves to the House, and we get our first Senate proposal. The Senate proposals in 1850 included one that called for families and another for male citizens. The male citizen's qualification clause was criticized by another senator for failing to provide for, and I quote here, provide for the lonely widow. Another senator responded that his bill would have provided for the lonely widow, but he phrases it as his would provide for the females and widows. During this time period, President Andrew Johnson, future President Andrew Johnson, was a representative from Tennessee, and he was very active in the homestead legislation proposing. In 1850, Johnson proposed a bill for every man who is the head of a family or every widow who is the mother of a minor child. But the next year, when Johnson proposed a different homestead bill, he dropped women and only proposed homesteads for every man who is the head of a family. And then the following year, he suggested any man or widow who is head of a family. Of the repeat players in proposing legislation, Andrew Johnson was perhaps the most inconsistent. He never quite used the same qualification clause and never seemed to have a good justification for any clause he used. So despite all of these various proposals that came forward in 1850 and 1851, neither the House nor the Senate really talked about unmarried women at all. Finally, in the 32nd Congress, which now we're up to 1851 to 1853, we had direct conversation about unmarried women. An 1852 proposal used his or her language throughout the statute and was to apply to any person being the age of 21 or head of a family. During these homestead debates, there was mention of only whether maidens or also old maids would be included. Joseph Cable of Ohio argued that unmarried women should be included so they can later marry, but he didn't necessarily expect the women to actually farm the land. Andrew Johnson spoke of a biblical justification for providing homesteads for widows and orphans, and more support for at least including widows came from a variety of congressmen. In May 1852, the House was debating the Qualification Clause, and a proposal came before the House to limit homesteads to married men. This proposal was accused as creating an invidious distinction against single men. And one representative went even further and argued that single women deserve the same rights as single men. There was actual laughter on the floor of the House in response to this argument. A few days later then, the House passed a homestead bill without any provisions for unmarried women. So now moving to 1854, there continues to be additional discussion in Congress about what to do. The bills proposed in 1854 did not initially provide for unmarried women. Then, in early 1854, there was a motion to add single men. This motion prompted another motion to add unmarried women. So this in turn, once again, led to joking about unmarried women, and specifically here, how Congress should include unmarried women simply to benefit the bachelors who might homestead. So it seems like this proposal to include unmarried women was largely made in jest by a bachelor in Congress. And again, it generates laughter on the floor of Congress. So after sort of this joking bit of a dare to include unmarried women, there did actually come a serious argument by William Berry of Mississippi that women deserved homesteads just as much as men. Berry at this point proposed the language that would ultimately become the law. He proposed a qualification law that would allow anyone who is over the age of 21 or anyone who is the head of a family to qualify. Although Berry's language would ultimately become law 8 years later, there was certainly no agreement to this qualification clause in the 1850s. Some congressmen started offering, though, at this point, clear support for including women. For example, William Dawson of Georgia argued that single women should be included because more women were needed on the frontier so they could give birth to children. Political maneuvering, though, ended the hope for any homestead bill in that session or the next. In the next session, a bill was introduced that did include unmarried women, but it was never debated or seriously considered. Then, in 1857, James Buchanan became president. Buchanan made very clear that he would veto any homestead legislation. The veto threat, though, did not stop Congress from acting on homestead legislation. The proposed legislation during this session was a mix of qualification clauses we've already seen before. Some bills for heads of family, others for any person, others for any head of family. The House passed a bill in early 1859, but there was basically no debate about it beforehand because they knew it was doomed. That bill was in fact tabled in the Senate, and no homestead legislation passed that year. By 1859, homestead laws were becoming even more politicized with slavery. Basically, at this point, the entire Southern contingent of Congress was opposed to any homestead legislation. But supporters of the Homestead Act were not dissuaded by this. Another homestead bill passed the House, again allowing for unmarried women to homestead. So if you're keeping track, then we have unmarried women included in bills passing the House in 1857 and 1859. In 1859, this goes to the Senate. The Senate objected to including unmarried women and passed only a version that included heads of families. On the topic of unmarried women, there were several Senate objections to including them. Graham Fitch of Indiana argued that women would claim land and then go and get married to a man with land, and that wouldn't be fair to settlers because the newly married couple would have twice as much land as if a married couple homesteaded together. Robert Johnson of Arkansas said that women don't want homesteads anyway, so there's no reason to include them. The version of the bill that was limited to just heads of families finally passed the House and the Senate, but as promised, President Buchanan vetoed it in 1860. In retrospect, of course, this was a good thing because a broader homestead bill was passed just 2 years later. So after Buchanan vetoed this in 1860, 1860 also brought the election of President Abraham Lincoln. Lincoln and his Republican Party had campaigned for the presidency with support for a homestead bill. The other thing, of course, that changes in 1860 is that the southern states had now seceded from the Union, removing most of the opposition to the homestead bill. Congress spent all of 1861 on war-related measures and did not take up a homestead bill at all. But finally, in 1862, it was time to pass the Homestead Act. Representative Galusha Grow, who was then the Speaker of the House, proposed a homestead bill with a qualification clause that would include unmarried women. There was no debate in 1862 about including unmarried women before the House passed the bill. The Senate also did not talk about it. The Senate took the bill from the House. The only change they made was an amendment to ensure that Confederate soldiers would not be entitled to take advantage of the Homestead Act. So with no further debate about unmarried women, the Homestead Act passed both houses and was signed into law on May 20, 1862 by President Lincoln. It went into effect on January 1 of 1863, the same day as the Emancipation Proclamation. So the final version of the Homesteading Act allowed for homesteading by any person over the age of 21 or for a head of household. The any person language included unmarried women, and the bill itself used he or she language throughout to describe the people who would claim homesteads. So that's a lot of history, and it's a lot of details about what Congress did. And so in the third and final part of my paper, I try to do some analysis of this history to put it in context and to help us understand what this all means. My primary goal was to compare the congressional statements to what actually happened with female homesteaders. I basically compared the legislative statements to the later lived experiences of the women who took advantage of their ability to homestead. This portion of my analysis relies very heavily on work done by historians. There are some really, really great historical accounts of female homesteaders. Unsurprisingly, though, historians look more at the lived experiences of female homesteaders and less at the law. My goal was to compare my legal research that I've done to the great work done by those historians. So, a few things stand out about how homesteading went for women in comparison to what the congressmen thought. Several politicians claimed that women would never want to claim homesteads anyway, so there is no reason to include them. This turned out to be wrong. Unmarried women showed consistent interest in claiming homesteads. While early scholarship on homesteading treated women as reluctant participants, many scholars have since shown that unmarried women eagerly took advantage of their homesteading rights. Especially after 1900, the number of unmarried women really expanded. While there is no nationwide data available, when scholars study particular areas, they generally find that single women made up more than 10% of the total homestead claims. So several politicians claimed that women would never meet the statutory requirements, even if they wanted to. These politicians thought that women were too weak to reside on a homestead for 5 years, to build a habitable home, and to cultivate the land. And if a homesteader failed to do any of these, they would not get title. Some of the congressional statements declare that women won't have the physical capacity to do these things, so they would never get title anyway. One senator simply described women as too frail to live on the frontier. This was, again, wrong. It turns out that women were just as successful as men about meeting their requirements and getting title to the homesteads. Now, it is true that many of these women did not actually till or cultivate their own land, but they were able to meet the homestead requirements by hiring men to do the cultivation, or they might have traded traditional labor, like laundry, baking, sewing, etc., for neighbors who would help with cultivation. So women's equality was another repeated theme that comes up in the congressional debates. By the time that Congress was debating these homestead bills, early feminists were making sex equality arguments. In fact, a few sex equality arguments even appear in the congressional record about the homestead debate. And although a couple of congressmen were willing to go on the record and argue that women deserved as many rights as men, other members of Congress found the mere suggestion of including unmarried women to be comical. In total, I counted 5 instances of laughter when legislators discussed including unmarried women, which is particularly interesting because although including unmarried women was a laughing matter for many members of Congress, ultimately they were included in the final version of the law. It is worth noting, though, that the Homestead Act is not gender neutral. Remember, there were 2 ways to qualify: any person over the age of 21 or by being a head of household. Unmarried women would qualify under the any person provision, but a married woman would not qualify anywhere. By definition, a married woman's husband was the head of the household, And a married woman would not qualify as any person because she lost her separate legal identity upon marriage. So although the Homestead Act of 1862 did not embrace equal rights for all women, it did create a pivot point for American land distribution. Future land laws generally referred back to the Homestead Act of 1862 for its qualification clause. So for example, the Homestead Act of 1866 allowed land to be disposed of according to the Homestead Act of 1862. Instead of Congress going back and again debating qualification clauses in future years, they simply used what they had passed in 1862. Now, this reference back did not occur 100% of the time, but moving forward, the default position was to include unmarried women. Plus, over time, the Homestead Acts were mostly interpreted in ways that were generous to women. So I mentioned at the beginning that this is the second in a series of papers on female homesteaders. The first paper was published in 2020 in the Nebraska Law Review. That paper looked at how the land department treated challenges by deserted wives who were trying to prove up land. So while Congress was talking about including unmarried women, they were thinking about women who had never been married. By a deserted wife, I mean someone who traveled to the frontier with a husband. The husband claimed a homestead. He then abandoned his homestead and deserted his wife. Those deserted wives litigated in order to have the right to prove up on the claims that their deserting husband had made. It took some litigation and it took some time, but ultimately the land department came out in favor of allowing deserted wives to claim homesteads. It's just another piece of evidence that these homestead laws were interpreted rather liberally for women's rights. Speaking of women's rights, although it seems like very few legislators thought of the Homestead Act of 1862 as being a law promoting women's rights, it sort of ended up having that impact. And I say that for a couple of reasons. So first, the unmarried women who received land patents from the federal government broke traditional gender norms and experienced newfound freedoms. Historians have argued that some of these women did not want to give up their newly found freedom that came with owning land for the first time. Other historians have argued that women's independence and their importance to community building led to early women's suffrage in the Western United States. Other historians might respond that instead the Western United States was simply trying to woo more women to the frontier by offering the vote, although perhaps that's a bit like Congress trying to woo more unmarried women west with the promise of free land. I can't settle the debate about why Western states offered early voting rights to women, but I can add that this is something Congress simply did not discuss at all as they were debating the Homestead Acts. A discussion of suffrage simply does not appear in the record. So although the purpose of including unmarried women was not to promote suffrage, homesteading rights and voting rights have a unique comparison. The homesteading bill was being debated during a time frame where early feminists were advocating for women's right to vote. A major argument against women's suffrage was the argument of virtual representation. The argument here that married women were already represented by their husbands, so they did not need a separate right to vote. The same reasoning was justified to exclude married women from homesteading. A married woman did not need her homestead because her husband got one. However, that comparison breaks down because with voting, an unmarried woman did not get a vote, even though she had no husband to protect her. But with homesteading, an unmarried woman got land precisely because she had no husband to claim that land. So this leads me to an important observation. The Homestead Act did a lot to remove unmarried women from operating under the shadow of marriage. Even just the fact that Congress talked about unmarried women was unique. Scholars have described lawmakers' treatment of unmarried women during this time frame as generally being one of willful blindness. Because lawmakers, and here I mean both judges and legislators, thought of unmarried women as being in a temporary state because they assumed all women would marry. So they could basically ignore unmarried women as they legislated about women's rights. So it was progress that Congress even bothered to talk about unmarried women, let alone ultimately decide to give them free land. And Congress, of course, went even further because Congress created a direct relationship between the federal government and women. Normally, women at this time access government benefits through men, either through fathers or husbands or even deceased husbands as widows. But here the federal government created a direct relationship with women by giving them title to land. This was, in a word, entirely progressive for the time. So despite my discussion of women's rights, in framing this as a progressive law, it is pretty clear that Congress was most concerned about women's traditional role of marriage and reproduction. Most conversations about women talked about them as future wives and future mothers. The major consensus was that women should be included in the Homestead Act because they would civilize communities and they would help with settler colonialism. Marriage rates were slightly lower in the frontier than in most of America, and women married a bit later. But the reality is most of these unmarried women homesteaders did ultimately marry. Many started families, and almost all contributed to community building in some way. So in conclusion, Congress decided to give women property rights because they wanted those property rights to encourage women to move to the frontier, so those women would become wives and mothers and help civilize the American frontier. So even though Congress did not think of this legislation as feminist and progressive for women, I ultimately think that it had that impact. So I will end there. I look forward to your questions, and I will also say if someone has a story of an ancestor who was a solo female homesteader, I would absolutely adore hearing that as well. So thank you for listening, and let me open it up to questions. Yes.
Have you identified any individuals or any groups that were advocating for women at that point? And sort of related, women out on the prairie, was this pressure coming on to Congress people representing their home states to make that available for their states?
Yeah, so I'll take the second one first, is there's certainly some congressmen, especially from eastern states, who thought of this law as important to their state because it would get the most impoverished citizens out of their states and move them out so they could have a better living. So I do think that if you think about this as benefiting both the new states and the old states because the assumption is that the poorest citizens will leave, I think that's why Eastern representatives were supportive of it. In terms of, were there any sort of groups or individuals who were particularly supportive of unmarried women? Not really. I tried to look, so of course I'm charting who makes what statements, who proposes what types of laws, to see if I can come up with a political breakdown, a sectional breakdown, right, a sort of geographic and age, any sort of breakdown. And my answer is I couldn't, right? It didn't seem like there was any way that you could tell by looking at somebody's politics or where they were in the country what they would think about unmarried women. Now, Galusha Grow, who was the Speaker of the House in 1862 when it ultimately passes, he was one of the most consistent supporters of unmarried women. And he just never talked about why. His biography, though, maybe like gives us a little idea of why he would do this. So Galusha Grow, his father died young, his mom was a widow. She moved from eastern Pennsylvania to western Pennsylvania, and she bought like a 400-acre farm. Now, this is not Homestead Act, right? But she was a widow who moved west, claimed land, and raised her family there. So, well, you might think he's seen this modeled before. He thinks that women can do it. He thinks it's an opportunity for women who want to support themselves. His biographers, though, never make the argument that he had any sort of inclination towards feminism, so to speak, or women's rights. Instead, they say that his interest was basically in families, homes, babies, and they have this great quote of like, Galusha Grow wanted homes, babies, plows, and freedom. Right? And so it all goes together, right? In order to have that, you have to have women. And so I think he's maybe the most notable one and kind of the only one I could find any evidence of why he might care. Other questions? Yes.
Was it a period of 5 years that they had needed to be able to actually earn their land?
Yeah, so the Initial Homestead Act of 1862 offered you, so you had to live on the land for 5 years. And during that 5 years, you had to build a habitable home, and you had to cultivate the land. And then after 5 years, you would go back, you would show evidence that you had done this, you turn in your paperwork, and you would get actual title, so fee simple title, like full ownership to the land. You had up to 7 years to do it, but had to do it within the sort of 5 to 7. A few years later, Congress comes back, and they reduce it down to 3 years, trying to make it easier. But yes, the initial one was for a 5-year period.
Do you have a sense of the success rate of women versus men? Because the success rate on men was actually quite low. After the 7 years or so, my understanding there were maybe about 1 in 5 that was successful. Defined as such.
Yeah, so I have no data sets, and I have not played around with any data, right? But a number of people have gone out and have pulled data. I mean, sadly, we don't have any nationwide data, right? It would be beautiful if there was just a repository of this, right? But it takes hard work to track these things. And so it's normally happened at kind of the county level, right? Somebody will go into a county, they'll do research, they'll pull out the land titles to try to figure out success rates. And of all of the studies I've read, people are saying that unmarried women are just as successful as men. And like what I would point out here is not just as successful as unmarried men, because, of course, most men who homesteaded had a wife who was helping them, right? But you'd never know that looking at the paperwork, because if a married couple went to homestead, the husband's name would go on the paperwork, and you wouldn't know if he had a spouse or not. Whereas, of course, if a woman's name was on the paperwork, you know she's single, right? So it seems like they've been finding at least as successful as men, and men here including both married couples and single men. Yes?
So you mentioned, and again, this would be anecdotal based on, I guess, what you just said about the data, but that there was a concern in some of the earlier acts about unmarried women claiming land and then marrying and kind of building these little mini empires. Did you see any of that play out?
Yeah, so that absolutely happens, right? So like the senator who's worried that, and, he calls it fraud. Like, it's going to be fraud because an engaged couple will go out, they'll both get land, then they'll get married. I mean, I don't necessarily think of that as fraud, but they did, right? They're really concerned about people taking advantage. So we know that that happened with couples. We also know that it happened with daughters, and of course sons as well, who traveled with fathers, right? So that was definitely a strategy is, you had to be 21, right? But if you have a 21-year-old unmarried daughter, she can go out and homestead with you. She can get a piece of land. She can prove up on it. Once she gets title, she can transfer it to dad. So we know that there's definitely some women who did it for that purpose. which I think the original, like the people who wrote the legislation would have been displeased about. There's not a lot of litigation about that though, because it's kind of clean. What there ended up being litigation about was women who started off as unmarried, but at some point they wanted to get married. And of course, if you started as married, you could only get one homestead. But if two unmarried people each claimed a homestead, you might end up with two, right? And the land department actually goes back and forth on this a little bit. So for a while, the argument was, well, that's fraud. You have to give up one homestead if you get married. Well, then the government realized what we're doing is disincentivizing marriage, right? You're basically looking at an engaged couple and saying, please don't get married for 5 years. Well, the government doesn't like to do that, right? Like the government loves it when people get married. They want people to be married. So for fear that they were disincentivizing marriage, they actually ultimately changed the law at an administrative level up through the land department to say that as long as you were single when you claimed your homestead, and you could meet the other requirements, that you would actually be able to prove up on two of them in husband and wife, because any other rule would have kept people from marrying. And like, again, the big goal is to get people to marry. So it's a great question because there's actually a ton of like land department history about that exact question.